does the DPC consider to be good practice when it comes to age assurance?
Thanks a million. Sorry, I was having issues there with my mute button. Yeah, well, I mean, I think the first point to accept is, as we all know, there's no silver bullet when it comes to age assurance, and not all situations are going to require the same level of assurance. So I suppose it follows that appropriate mechanisms will likely vary from context to context, and this will depend on factors like the service being provided, or the sensitivity of the personal data being processed. But I suppose in all cases, the measures that an organisation takes should be proportionate, and they should really be grounded on a risk-based approach. So this essentially means that there should be greater stringency and greater levels of certainty provided by the particular age assurance process where the processing of personal data is of higher risk to the user. So to us anyway, the reality is that a holistic, layered approach to age assurance is going to be the most effective and robust protection. It's going to ensure the most robust protection of children's personal data. And it's something that the DPC really strongly encourages. Many organisations are going to need a combination of age assurance tools in order to ensure that they have the most effective approach in place. So, take, for example, upfront age assurance mechanisms like age checks. That might only be the first link in an organisation's age assurance chain, so to speak. And it's followed by subsequent steps and interventions that are perhaps aimed at achieving a higher degree of confidence about a user's age. Now, we're aware through our consultation activities with organisations of a number of age assurance methods that are currently being trialled by organisations. And interestingly, artificial intelligence seems to be a front runner with a number of these organisations. And while we certainly welcome that organisations are developing and evolving new technical measures for age assurance, we'd have to say at the moment there's insufficient evidence as to the efficacy rates of these types of AI models. But more importantly, there's insufficient evidence as to how long it takes before an organisation can state with some degree of certainty, that a user is over or under the age of 18. We fully appreciate that these AI models are in their infancy, and that it will take some time to get to a decent level of certainty. But our concern, I suppose, as regulators, is that while this process of attempting to infer the age of a user is going on, child users are going to continue to slip through the net, so to speak. So for us, a really important message to get across to controllers is that you have to have sufficient, robust age assurance measures in place in the interim while they're testing these AI models. Because at the moment, based on what we're hearing from stakeholders, it would appear that the approach seems to be that until these AI models are more established and more adept at inferring age, organisations are actually continuing to rely solely on their first line of defence, and that's self-declaration of age, which, as we all know, for a fact, doesn't work on its own. So this is something the DPC is watching really, really closely. But look, whatever the combination of methods that an organisation is using, the result has to be demonstrably robust, it has to be effective, and it has to achieve a level of reliability that's proportionate with the risks that are posed by the processing in question. And just in that regard, one point I'll raise, and it's something that cropped up in the course of our public consultation on draft guidance that we've produced entitled Children Front and Centre Fundamentals for a Child-Oriented Approach to Data Processing. And we found that many organisations appear to view the principle of data minimisation as a potential blocker to achieving effective age assurance. And this is certainly not the case. It's something that the DPC will be strongly emphasising in the final version of our fundamentals. Of course, any age assurance mechanism that's developed or utilised has to comply with the standards of data protection. That goes without saying. But these principles shouldn't be used as an excuse to carrying out effective age assurance measures when there's a legitimate purpose there to do so. So from our perspective, as long as organisations are only collecting the minimum amount of personal data for the purpose of achieving a relative degree of certainty about the age of a user, and provided this personal data is securely stored, it's not used for further processed for any other purposes, and that it's not retained for any longer than it's absolutely necessary, the DPC certainly doesn't see any reason why age assurance mechanisms would be in contravention of the principle of data minimization. So that's just something I thought I'd raise here today, because it struck us as important during our consultation that there's kind of this ill-informed school of thought floating around out there that data minimization is a blocker to effective age assurance, which isn't the case. But I suppose coming back to your question as to what good practice looks like, the DPC doesn't really consider it appropriate for regulators to prescribe what methods are most appropriate for organisations, because, you know, as I said, this will vary from context to context. But we do consider that common standards around age assurance, much like those proposed by the Five Rights Foundation in their recent paper, should be established to give organisations an indication of the baseline expectations when it comes to age assurance. And in fact, you know, a number of the standards promoted by Five Rights, for example, that age assurance should be privacy preserving, that it should be proportionate, that it should enhance children's experiences and not merely restrict them. These are actually reflected in the DPC's 14 fundamentals for a child-oriented approach to data processing. But I suppose ultimately it is up to organisations as data controllers themselves to decide what age assurance methods are most appropriate and importantly most proportionate for them. And we would see this as a really dynamic issue that organisations really need to keep under constant review in light of all of the emerging technologies that we're seeing. And I think another important note is that these models are subject to regular efficacy assessments to ensure that they continue to be robust. But just to finish up, for the DPC, I suppose good practice really starts with organisations taking a really hard and honest look at their platforms and at the services they're offering to children, and the impact that these services may have on children's rights. Because I suppose if children's best interests are truly at the heart of these services, as so many organisations claim to be the case, then there should really be a concerted effort, you know, by organisations to drive those higher standards of protection and to ensure that children can enjoy the safest, most age-appropriate and the richest user experience possible. And I suppose the DPC sees effective age assurance as the gateway really to ensuring that this happens.
Thanks very much indeed. That's a timely reminder that there isn't going to be somebody somewhere in an office in Dublin or Budapest or wherever it is telling any individual company what they must do, because the companies themselves have the primary and initial obligation to look at things and make their own decisions about what's reasonable and proportionate, because context is everything in this space. So thanks a lot, Jenny. We'll be coming back to you